All right, welcome to Module 5C. I'll be talking about intellectual property. We're going to define what it is, take a look at the four major forms of intellectual property, and then talk about licensing and how licensing is different from outsourcing. Intellectual property to the small business, the new venture, is, in today's environment, probably your most important asset. Rather than manufacturing and big buildings and lots of bricks and mortar, intellectual property tends to be many companies' most important assets. In taking a look at intellectual property, you have to decide whether or not the property that you have, whatever this idea is, and we'll talk about what is really intellectual property and what can be protected, how that relates to your firm's advantage, your competitive advantage, and whether it has value in the marketplace. Is it something that you could sell? Is it a process or an idea that somebody might want to buy? Here's some mistakes that are commonly made. The text it does not necessarily point out all these, but you know that these are important things. They don't realize that they've got it. And say, well, gee, it's just a great idea. But if somebody knocks it off, if it's a great idea, and you work hard to make it a reality, and somebody comes in with a knockoff and steals your idea, unless you've properly protected it, you've got no recourse. And people will do that. Again, here's the four forms, four key kinds of intellectual property. We'll take a look at each of them. First is, and the perhaps easiest, is a copyright. And a copyright is nothing more than that little C in a circle up here. The year, your name, where it is. All rights reserved, don't really need that. Sounds nice, I typically do that, but legally, it's not necessarily necessary. All you need is the year, your name, and where you are. There's a thing called a common law copyright. And you may have heard of this, or the poor man's copyright, or the poor man's trademark. Same. We'll see in trademarks you can do the same thing. You want to copyright something, and the question is you wrote it in 1999. Somebody else steals that, copies that. You want to try and enforce your copyright. Well, who says you wrote that in 1999? Maybe you wrote it yesterday after that other person had written their document. Maybe you stole their document, and what you did is you typed in copyright 1999. How do you prove that you really did it back in 1999? Well, the answer is simple. You may have heard of this in prior courses or as part of your life experience. What you do is you take a copy of the document with the copyright notice on it, the C in a circle from Microsoft Word or whatever word processor you're using, put it in an envelope, seal the envelope, mail it to yourself. You get it back. Do not open the envelope. Leave it sealed. Put it away. Now, in 2008, when somebody comes and says, hey, I wrote this thing, and you say, no, I wrote this back in 1999, you can go to a court and have a judge open that envelope and see that that document is in there. What's the sealed envelope got on it? A postmark. a date from the United States Postal Service. It's called a poor man's copyright, poor man's trademark. But, copyright, there's a better way. For $45, you can, get your own protection. You can get government protection. If somebody rips off your music CD that's been copyrighted, or your DVD that's been copyrighted, and coming from another country, pirated, trying to sell it on the U.S. market, if you get wind of it and find out, the Customs Service has the authority then to seize that as contraband, okay, and bring an action. You see the website there, Library of Congress, Library of Congress web.Library of Congress. It has more information than you'll ever want to know about copyrights, and it's very easy to do. And you can copyright documents, CDs, DVDs, photos. With a CD, you can copyright the music, the arrangement, you could, of course, copyright the cardboard insert that goes in there, the label, as it were. With music, you can copyright the lyrics, the actual song. Again, if you're doing a compilation of oldies and you have the rights to use those oldies, you can do that. You can copyright that individual compilation. But the downside is that it only prevents copying. Okay, doesn't prevent reverse engineering or other forms of piracy, as it were. In a similar fashion, there was a problem up to a number of years ago called URL squatting, where people were buying up potential URLs, website names, and holding them hostage, essentially. Well, there's a federal law against that now. You have to have a reasonable business purpose or a reasonable purpose to get a particular website. All right. If you want a specific name, a .com name, like mine is Zeiss.com, I had to show that I was running a business called Zeiss and Associates Limited. All right. So again, they've kind of cut out that problem. The Canned Spam Act, you cannot, you get into problems with the email spam, and I'm sure you're aware of that. What's protected by a copyright? As I said, lots and lots of stuff. Computer software is copyrighted. Some processes, computer processes, software processes are patentable, but much of it is just a copyright. And again, remember that it protects only copying, not reverse engineering. Of course, the usual graphics works, picture works. Be careful grabbing stuff off the web and using it, say, on your website or in other materials that you might be violating somebody's copyright. You'll note, just as an aside, I'll mention there are lots and lots of innuendos here, and if you haven't taken a intellectual property course, maybe if you actually start a business and are involved with stuff that has significant intellectual property, maybe you want to take a course in that, or at least a seminar, because there are lots and lots of loopholes. For instance, you'll note in the supplemental reading that I put out, I use materials from a variety of sources, all of which are copyrighted, but there's a thing called a fair use doctrine that applies to educators and people who are using this stuff for academic purposes. Again, lots and lots of ins and outs, so it's not especially easy thing, but you should be aware, of intellectual property. The second kind of intellectual property that we should deal with is something called a trademark. And a trademark is typically a logo, a slogan, a design, or these days an icon. Like the C in a circle for a copyright, a trademark is a superscript TM, and it's after the mark. So you would have Snapple with a little TM after it, above it. All right, and it's trademarked. It's your and again, exactly the same poor man's trademark, like I just talked about a few moments ago, like the poor man's copyright. In your business plan, if you have a logo, a slogan, a design, or something like that, a name that you are going to trademark, make sure everywhere that you use it, both in your business plan and if you actually start a business, everything that thing goes on has the TM. It's important. Now, besides the common law way, you can register it, and New Jersey has its own trademark process, and you can see there, you can renew it, every 5 years. But it's good only in the state of New Jersey. But if that's the only place you're running, if Bob's Landscaping Service is only running in New Jersey and we want to trademark that slogan, that name, as it were, or Bob's Best Landscaping, whatever, you can do that. Another way to do it is to register it with the U.S. Patent Office, U.S. Patent and Trademarks Office in Washington, and that's federal. And it's good for 20 years. Has to be used in interstate business, which means you've got to show that you've used it. Well, suppose you're not doing interstate yet, but you want to spend the money, and you can see what it costs to do it, roughly. If you use a commercial service, such as fortrademark.com, suppose you're not really doing business out of New Jersey, outside of New Jersey at this point. Well, you've got a cousin over in Brooklyn. So what you do is you send your cousin a proposal or some literature with a cover letter saying, thank you for your interest in our company. Here's what we have to offer. And again, keep records that you sent this out on such and such a date. Maybe keep a photocopy of the envelope, or ask your cousin to keep the actual envelope showing the postmark, okay, so that you can show that it was used in interstate commerce. All right, doesn't mean you have to have the customer, just means you have to send literature out. One of the things you have to, of course, the other website, U.S. Patent and Trademark Office.gov, can tell you lots and lots of information about how to register your own trademark if you want to do it yourself. One of the reasons for the cost of using a commercial service is that you have to do a search to make sure that that mark isn't registered someplace else. And, it's your burden. You have to do it. Okay? And you can, there are ways to do it yourself, but takes a lot of time. You may not have the time. It may be worth the $800 to have a commercial service do it. Question is whether your mark is worth registering. A lot of big businesses don't even bother registering a lot of marks. They may just put a TM on them to keep it because they've either got the mark is either so well associated with their brand image, like Snapple, made from the best stuff on earth. I'm sitting here with a Wendy's cup right now with some iced tea in it, and some of the marks on there are strictly TMs as opposed to the actual Wendy's logo, which of course they have done with an R, a registered trademark. But again, a lot of companies say, hey, either my mark is so heavily attached to the brand, or it may be very transient. By the time somebody else comes in and tries to grab our mark, it's going to be useless. It's not going to be worth anything. You know, it's a short-lived thing, so it's not worth spending a lot of money. Now, the other issue is that a mark need not be strong only in your area. You know, it goes by industry, and again, I'll talk about that in a moment. Here's an example of trademark. Both the name, the font, the symbol, and the slogan. Here's a kind of a summary chart that talks about trademarks. The state of New Jersey differentiates between a trademark TM and a service mark SM. Okay. Federal law doesn't necessarily do that. TM works for either one. There are a few other kinds of marks out there, and you can see the example here. A collective mark, usually used by a co-op. We're going to talk about co-ops later in the course under marketing, such as the, well, they actually use it down below, such as, well, the Florida Orange Juice Growers Cooperative, okay? And again, you have a certification mark as to where things came from. Underwriter Labs is a good example of that. What's protected under trademarks? Here we go. All of this kind of good stuff. All right. Again, but you have to make sure you have the problem of making sure that you have the right to use it. Example, in the early in the late 1960s, right, Xerox Corporation was in the business of making computers. They came out with a new line of computers in the late 1960s, early 1970s perhaps, called Sigma, S-I-G-M-A. Sigma 5, 6, 7, 8, 9, so forth. Came up with this global rollout, predominantly in the U.S., across the country, you know, a marketing rollout of the Sigma line of computers, and trademarked it. Well, unfortunately, their searches of the trademark were not that, wasn't 100%. Okay, wasn't that good. They came out, they started their rollout, and all of a sudden, this little guy up in the San Jose area of California contacted them and said, hey guys, my little company has been building a line of small computers, mini computers, for the last 5 years under the name Sigma. I own that trademark. I used it first, and the law is clearly that the first to use it owns it, at least under common law. And he had a registered trade, and he had a trademark, okay, in California. That was a major problem to Xerox. What do you do? You know, do you scuttle this multi-million-dollar marketing campaign, change the name of everything? Answer, no. They bought the guy out. He shut down his company and went to live in the Bahamas on the millions of dollars that Xerox paid him just to get that trademark. So, it may be worth something. One of the things you want to look at is, again, is your mark worth registering? That was on the prior slide. If it's a strong mark, if there's a mental connect, you want to protect it. Coke, Pepsi, Disney. Okay? Very, very strong, very immediate mental connect. Okay? You know who they are. It doesn't have to be worldwide, countrywide even. It can be within an industry. Kellogg is an engineering company. Kellogg is also a cereal company. What about Perl? And I don't mean the programming language Perl. What's Perl? You know, with a capital, with as a name. I know what pearls are, but as a name. Well, Perl is a craft company. You know, one of these stores that sells crafting items, particularly in the South. Pearl, different company, is Pearl Vision, eyeglasses. And if any of you are drummers, I'm sure you've heard of Pearl as one of the big names in drums in the music business. Again, they don't compete with each other. There's no chance that Pearl Vision and Pearl drums are going to be confused for each other. Now, if one of the companies had chosen exactly the same font, exactly the same design or logo, yes, there's things called unfair competition that would come into play, but you know, it can be within an industry. If you have a strong mark and you do not protect it properly, you could have problems. It's called dilution. Xerox. For a while there, people were saying, make a Xerox of this with a small x. Xerox itself went on a major campaign to say, make a Xerox photocopy. Use the word copy. Use the word photocopy. They wanted to protect the name Xerox from becoming generic. Band-Aid. They are now Johnson & Johnson Band-Aid adhesive bandages. Why? Because they didn't want other companies selling Band-Aids with a small b. Okay, we've also got to look at patents, which are the highest form of intellectual property protection. And what it does is, as the slide says, excludes others from making, selling, or using that invention for the term of the patent. Some statistics down at the bottom, but let's take a look. The idea of a patent is that the concept let me back up, I apologize. Let me back up a little bit. The idea of a patent is that instead of keeping your wonderful idea a secret, you publish it. You put it out there in the public domain, so that people can take that step forward, that advance, and build upon it. And that's the way we get progress. That's the way we get more innovation. And to stimulate and incent people to publish their new ideas and their new processes and their new innovations, the government gives you in return a right to keep other people from knocking it off and imitating it for a certain length of time. But they can take your patent and build upon it, and if they come up with something better than you came up with, significantly better, they can get a patent of their own. Okay. Different kinds of patents. For patents, we typically think of in terms of pieces of equipment, a patented device of some sort. But you can have processes as well, computer processes, industrial processes. Design patents are good. In the supplemental reading, you'll see about patenting, it's called patent applique, that many of the designers are turning to patent protection to prevent low-cost knockoffs of some of their designer fashions. We've got some costs there. These costs come from the Small Business Incubator as to what it costs for, in general, for a patent. And the cost drivers are not legal costs. They're flow charts, descriptions, research of the prior art, because you have to show to the patent office how different is your idea from what already exists. How did you take a quantum step up from the prior art? The problem with a patent is that it may or may not be enforceable. Even though the patent office gives it to you, you may have problems enforcing it. The e-commerce patents, people try to patent the idea of a hyperlink or other processes that just didn't work. Okay, and sometimes they got a patent and then tried to shut somebody down, and somebody said, hey, wait a minute, we were doing this 2 years before you even filed for your patent. And of course that says, it invalidates the patent and says that person's allowed to use it. Here's a write-up of what a patent really means. So I would ask you to take a look at this and look at the slide, the PowerPoint slide that's there. These are the 3 basic requirements. Again, it has to be useful, has to have some purpose, has to be different, not obvious. Having a purpose, design patents, okay, typically cover things like, traditionally have covered things like wallpaper and fabric. That has utility. All right, it's the pattern itself has a utility. So utility doesn't necessarily mean that it's got to be something that's functional. Here's the types of patents, as I mentioned. Plants can be patented. Haven't seen animals patented yet, but that may happen too. A business method, a computer process. You'll see the Priceline and Netflix business processes are patentable. Again, whether they hold up or not is sometimes a question. The 4th kind of intellectual property is trade secrets. A trade secret is defined here. Can include lots of things, as the chart says: marketing plans, formulas. If it's known to the general public or that competitors can find through your website or other ways, it's not a trade secret. You have to show, you have to convince a court, if necessary, that this thing was protected. The ways you protect it typically are making people sign out for it, stamp every page or print at the bottom of the page, proprietary, secret, restrictive, something like that, so that those pages, so that it's clearly shown what is confidential information. And you can see the more secretive you want to keep your operations, you may want to control people coming in and out of your building. You may want your employees, as I talked about earlier, you may want your employees to sign trade secret agreements that they will not divulge this information and enforce it. Unfortunately, there are problems with trade secrets. You can put together a non-disclosure agreement, and again, there are standard forms out there that say, you can't tell, I'm telling you this, but you can't use it. You can't give it out to anybody else. The problem that we find with a lot of small companies, particularly in these small business incubators, is that it's, one, difficult to enforce. Did they learn? How do you prove that they stole it from you, as opposed to finding it out through some third party or through some source? And companies, for marketing purposes, tend to put a lot of information out on their websites, not all of which should be there because that's in the public domain. Also, big companies don't like to sign non-disclosure agreements with these little entrepreneurial outfits, new ventures. And the reason is the big company says, hey, wait a minute, I'm Hewlett Packard. May have some great idea that's relevant to our business that maybe you'd like to license, and we'll talk about licensing in a moment. You'd like to license this idea to us or sell it to us. But you know what? We don't know what's going on within Hewlett Packard as this huge corporation. Our own engineers may be working on almost exactly the same idea. And if we sign this non-disclosure agreement, 2 years from now, we come out with, and we don't go anywhere with it, and we don't strike a deal, but 2 years from now, we come out with a product that's very similar to what you had, and you sue us, saying, you violated our non-disclosure agreement. And then we have a problem because we have to convince the legal system that we invented this on our own. Our engineers came up with this independently. So thanks, but no thanks. And that's what happens. So what happens is these little companies frequently have to take the risk of going, if they want to sell their idea or sell their product or sell their process, have to take a chance and just tell the big company and hope for the best. Well, what do you want to do? If you own this intellectual property, you want to make your product, you want to produce your service, you use your process to your advantage to make lots and lots of money, or you may want to allow somebody else to use that intellectual property. The idea is that you can increase revenues. We're going to talk about infringement in a moment. The idea is that when you give somebody a license, you let them build it, build your product. In return, you get a fee. You get some money for this. But the contractor, whoever you licensed it to, uses it for his own company and his own label. That differs from outsourcing in one significant fashion. In outsourcing, the contractor makes it for you. Instead of you manufacturing it, you are going to somebody else and they manufacture it for your company with your label. Okay? Significant difference. If you don't license it, or if a person uses your stuff without buying a license from you, it's called infringement. We all have heard about Napster, I would hope. Big problem. It was solved. Be careful of the photocopier, making photos of things, unless, as I mentioned earlier, you have some one of these loopholes that fortunately, educators, professors have to use this stuff for educational purposes. You can't just go copying things, even from a website. Be careful about grabbing stuff from a website and using it for your own business. Okay? Don't assume you own the rights. What about a picture? Case in point, had a client who owned a florist. He got married, and for the wedding, he made his wife's bouquet. And the wedding photographer took the typical picture of, the hand, the ring, the bouquet, and this kind of stuff, and really, really nice. Well, my client, the florist, used that picture in a newspaper ad. Got a phone call from the wedding photographer saying, "You violated my copyright. You owe me money for use of that photograph." Wait a minute. I paid a lot of money for these wedding photographs. They're my property. I have the rights to them. I can do whatever I want. Answer, wrong. On the back was stamped copyright of Bob's Photo Service. If the guy had taken the pictures with his own Nikon camera and had the film developed, or if it's digital, just had it printed out, fine, no problem. But these were copyrighted. They were from a commercial photographer. What was really protected? Was it the chemicals, the paper? Not really. What was protected was the focus, the framing, the lighting, the creative things that were done to make this photograph an outstanding photograph. That was the intellectual property that was protected by the copyright owned by the wedding photographer. So if you wanted to use the ad, you had to pay the photographer some extra money. The problem with infringement cases is they're expensive. So if somebody wants to use your stuff, or if somebody wants to use your stuff, sell them a license. Don't force them to infringe. Offer them for a fee. Obviously, get money for it. Just be realistic. Or if instead you're going to use somebody else's patent, copyright, trademark, buy a license. It'll save you money in the long run. Well, just one comment. There is no such thing as an international or global protection. You have to go to different places. Here's a website, WIPO.int. Go there. There are some. The European Union does have a common trademark and or intellectual property system. Most of the African nations have a common system. The more developed ones have more stable ones have a system. Again, be careful, but there are some countries that just do not recognize or protect intellectual property, particularly U.S. patents and those kinds of things. So be aware of it. Okay, practical matter. What do we want to do? We have a piece of intellectual property. Do we want to keep it or protect it? Should we share it? Suppose you have a new idea. These aren't new ideas anymore, but let's use them. What do we want to do? Suppose we decide to keep it. We can patent it or copyright it. We could, of course, keep it a trade secret. And that's always a possibility, but then we've very limited ourselves. Here's the advantages. If we have our own proprietary design, our own proprietary set of couplings, ways to interface this to that, okay, we can lock up the market. I've picked this example specifically for reasons I'll get to in a moment, but Apple has been, with its computers, well noted for protecting its interfaces so that you have to use only Apple add-ons and Apple products for your computer, as opposed to the generic Intel, Microsoft, Windows kinds of environment that has been more open. The reason I picked fire hoses and oxygen canisters is the second item down there. The first one is, hey, if you keep it and protect it, nobody may adapt it, nobody may pick it up, and it may be a dead end. You may get some standard, industry standard may come out there and just obsolete your design. The fire hoses and oxygen canisters is a slightly different problem. I go back to September 11, 2001, the 9/11 World Trade Center disaster. What happened there was that fire companies from all over the area were called and came in to respond to that emergency. What happened was each manufacturer of fire engines and equipment and things like breathing apparatus had their own proprietary system, their own proprietary interface of how you did things. Well, the idea was so that they could get the refill parts, the oxygen canisters and things like that. What happened, though, was that if the fire engine that you were on ran out of oxygen canisters for its breathing apparatus, and you went to the fire engine next to you, and if it wasn't from the same manufacturer, their canisters wouldn't fit your equipment. Your hoses couldn't connect to their hoses. Major problems. Government stepped in, FEMA, and said, you will standardize. And the way they did that is, of course, with federal funding that goes to the states to fund these fire companies, and said, if you don't standardize, you will not get federal funding. So it came back and hurt. These people had the great idea of, well, we'll capture all the refills and repair parts. The other possibility is that you can share your intellectual property, sell a low-cost license that I talked about, build a market, become an industry standard. I don't know who came up with USB as an interface, but industry standard, yes, very much. You get less revenue because you got other people making it. But maybe it's just a smaller piece of a bigger pie. Maybe overall you make more money. Don't be greedy. 2 examples. VHS, Betamax. Betamax was a superior technology, but Sony kept it close hold, wouldn't license it, lost out. VHS, I believe it was Matsushita who did it, and let everybody build VHS recorders, VHS players, and captured the market. Cell phones, same problem. Okay, last slide for this week. Here's the sales pitch, since I'm a lawyer. Just an idea. Again, and it applies to accountants as well. Maybe you need a general practitioner just like you need a family doctor, and maybe you go to the specialist when you need it. The idea of a business lawyer or a business accountant is that they should get in a dialogue with you, and you should want to get into a dialogue with them so that they understand you and your business so that they can be proactive. A person told me once, a number of years ago, I can call a lawyer and get an answer. The problem is I'm not sure I know the questions to ask. Well, that's a problem. Make sure you have somebody who knows what you're doing, who can give you some advice, who can be a mentor, as we talked about earlier, and work with you. Okay, next week we're going to explore marketing, advertising, and selling, which usually gets a short end of the stick, as it were, in a lot of textbooks, including this one. So you will see that instead of a textbook chapter to read for next week, I am supplying you with materials under the Read for Next Week portion, and take a look at that and we'll build from there. Thank you.